This is Bloomberg Law with June Grasso from Bloomberg Radio.
We don't get it! Shut it down!
Thousands of Starbucks workers at hundreds of stores across the country went on strike for one day last November to protest their union's lack of a first contract with the coffee chain, despite a nearly 2-year organizing drive.
We are really fighting to come to the bargaining table, and regardless of what Starbucks is advertising, they are not true to their word.
The union, Starbucks Workers United, won its first representation at the company in December of 2021 at a store in Buffalo, New York. Since then, it has won votes at more than 360 stores, but the union and Starbucks have yet to agree on a labor contract for any of the more than 9,000 union members. Tom Erickson is president of Teamsters Local 120.
At the end of the day, these workers want to be represented, and Starbucks should do the right thing, come to the table and support them.
Union members have filed hundreds of complaints accusing Starbucks of breaking the law in its efforts to fight off unionization. And now the Supreme Court has agreed to hear Starbucks' case over the firing of union workers at a Memphis store. Would you say that Starbucks has become sort of the face of the fight by management against unionization, or are other companies doing the same?
Starbucks has been fighting unionization really intensely and has been both exploiting all of the opportunities in the law to fight unions, but has also violated the law in many different ways. But they're not alone. We also see that kind of resistance to unions occurring now by what was formerly known as Twitter, also SpaceX, the Elon Musk companies, by REI, by Amazon. So I don't think Starbucks is alone, but it certainly is really following textbook anti-union strategies.
Yeah, I saw that it's facing more than 700 complaints before the NLRB for everything from firing union supporters, spying on workers, closing stores during labor campaigns. So this comes from the top, I take it? It's not the individual stores that are deciding this.
Right. This kind of labor policy is almost always at a national level. There might be occasional times where a manager goes rogue, but this kind of comprehensive anti-worker campaign is national labor policy for the company.
So tell us what happened in this case.
The case that the Supreme Court just granted involved 7 workers who worked at a Starbucks cafe in Memphis, and they sought to organize a union, and the company fired them. They alleged because of their efforts to organize the union. They had recently appeared on local TV talking about the union campaign, so there was no question that they were involved with it. Notably, Starbucks denied wrongdoing, but it did end up hiring the workers back. But in any event, in the meantime, the NLRB sought an injunction to get them reinstated. Frequently, when workers are fired for organizing unions, it can take many, many years for them to get their jobs back. Here, because the evidence was so overwhelming that Starbucks had violated the law, the board sought an injunction in court so that the workers would be reinstated while the legal appeals proceeded.
And so the question is the standard that the judge used and the Sixth Circuit approved of for granting the preliminary injunction. Is that the issue?
Exactly, right. These are called 10-day injunctions, and they're very important because they enable relief while litigation is pending. But they're not that common. The NLRB only pursues them in cases where they deem that the violations are significant and they have a strong case. And there's disagreement among the courts of appeals about what standards should apply to decide whether one of these injunctions should issue. And that's a legal question that the court appears poised to decide.
So the approach used by the Sixth Circuit here is, would you say, a more lenient approach, requires less of the NLRB?
Probably. So the Sixth Circuit applies a 2-part test, and that examines first whether a district court has reasonable cause to believe there was a labor violation, and second, whether an injunction would be just and proper. And it appears that that is slightly more lenient. So 5 circuits apply that test, and they are slightly more likely to grant injunctions. 4 circuits apply a 4-part test that's used in other cases involving injunctions, and those courts look at likelihood of success on the merits, chance of irreparable harm, balance of parties' interests, and whether an injunction is in the public interest. But the Solicitor General in this case, in opposing cert, took the position that I think is fairly well supported by evidence that, in fact, the 2 tests are pretty similar, and there's not that much difference in how they come out.
Yeah, I saw that, and so I wondered why Starbucks and business interests are so set on challenging this standard, and Starbucks said it was seeking to level the playing field for all U.S. employers by ensuring that a single standard is applied.
So Starbucks is saying that the circuits that use this two-part test are too lenient, and so they want one standard throughout the country. But I think what's also really going on here is that the business groups, including the Chamber of Commerce, which filed a brief in support of certiorari, are trying to get the court to send a signal to the lower courts and to the board that they should seek these injunctions less frequently and grant the injunctions less frequently. So I think what they're hoping for is a general tightening of these injunctions. You know, it's a little odd that the court granted the case. Technically, it meets certiorari standards because there is a split. But as the Solicitor General pointed out in opposition, it's not clear that the split matters that much. And it's not clear that this is actually a great vehicle for deciding the split, because it's not clear that in this case it would have come out differently no matter what standard was applied.
Yeah, so the NLRB said that it sought the injunction 21 times in 2022, down from as many as 38 each year during the Obama administration. Is it because the current NLRB General Counsel, Jennifer Abruzzo, says that her office is going to pursue these 10J injunctions more aggressively?
Well, I do think that the companies are concerned that these injunctions may be pursued more aggressively. I also think they're taking advantage of a conservative turn on the court. They think they have the opportunity to further constrain workers' rights, more so than, the courts that existed previously.
Would you call the Supreme Court the most business-friendly, anti-labor Supreme Court in modern history?
Well, I guess it depends when modern history starts. It certainly has real echoes with the court that existed before the New Deal, that routinely struck down regulations protecting workers and consumers, and that also really tried to constrain government power to protect workers and consumers. So I think one thing that's particularly concerning is, the series of anti-union and anti-worker cases that the court has issued, but also more generally its attack on government and on the administrative state. So in addition to this Starbucks case, the court has before it this year a number of cases that could really constrain labor board's power while it constrains all other agencies' powers as well.
So that's why I'm wondering, any hope that they would rule against Starbucks here?
Yeah, it's certainly possible, right? Each case is considered on its own merits. I think there's good arguments in favor of the standard that the Sixth Circuit used. It's never a good practice to predict what the court would do. It's more likely they'll weigh in favor of Starbucks, but you never know with a given case. But it certainly is a very strong pattern by this court in favor of big business and against workers.
Business groups urged the Supreme Court to take this case. And the chair of the Coalition for a Democratic Workplace, which is an umbrella group of hundreds of business organizations, said that court injunctions can force businesses to retain expensive assets, remain in unprofitable facilities, or reinstate employees who engaged in misconduct based on flawed theories or unsubstantiated allegations. Do you think that they have a point in that it takes a long time for the layers of review that the NLRB goes through?
Well, it certainly does take a very long time for these cases to be resolved. First, the board has to decide them, and then they typically get appealed through multiple levels of appeal. But that's exactly why these injunctions are so important, because if workers get fired for organizing unions, and then they are not reinstated under injunctions, even when the evidence is overwhelming, what that means is that they are out of work, or they're out of work at that particular facility for many, many, many years until the case is resolved. And once the case is resolved, the only remedies that are available to them are reinstatement minus back pay earned in the meantime. So there's really no disincentive for employers to violate the law. And so I think it's actually the opposite of what the business argue, that in order for the statute to be vindicated, these injunctions need to be available.
Is the real concern for businesses the costs associated with having unionized workers?
Well, unions certainly mean that profits within the company are distributed more fairly, so that workers get a fair share of the profits that the company is producing. I think there's lots of unionized companies within the United States that have learned to deal cooperatively with unions and that have really productive working relationships and that continue to prosper. But I think what Starbucks is most worried about is giving up control of any sort and having to share power with its workers. So I don't think it's just about the money, but also about the extent to which workers will have a voice in working conditions as well as increased wages and benefits.
How would you characterize these times for unions I mean, we've seen organized labor demonstrate its power last year through the UAW strike and the Hollywood writers and directors strike.
Well, certainly there's widespread interest in unionization in the United States. So we see both an uptick in organizing efforts, an increase in strikes, and polls that show that over 70% of workers would like to have a union. I think the big question is that energy going to translate into an increase in union density and a growth in unions? And there's a major challenge with achieving that increase, and that is that U.S. labor law doesn't effectively protect the workers' ability to organize unions. So you have all these Starbucks workers that have won elections across the country, and yet not a single one has yet reached a first contract. That's in part because the law doesn't effectively force the employer to negotiate a contract or to reach a settlement or to obey the law.
Would you explain that further? Because I thought that our labor laws were pretty robust.
So the law is very strong in the sense that it provides workers a right to organize unions, a right to negotiate contracts, and a right to strike. But in practice, the enforcement of those rights is really limited, and the penalties are very weak for violations of the law. So after workers win a union election, the obligation is on the employer to bargain in good faith, but there's very little ability to force that to happen. And so you have employers that bargain in good faith. We just saw that happen with the auto workers. We saw that happen with the Hollywood workers, where the workers and the employers did reach good contracts. But a lot of times when workers organize a union for the first time, employers either refuse to bargain or really drag their feet and aren't willing to reach first contracts.
Thanks so much for being on the show, Kate. That's Professor Kate Andrias of Columbia Law School. Coming up next on the Bloomberg Law Show, actor Alec Baldwin is once again staring down a felony involuntary manslaughter charge in connection with the fatal shooting of a cinematographer on the set of the movie Rust in New Mexico in 2021. I'm June Grasso, and you're listening to Bloomberg. Alec Baldwin is once again staring down a felony involuntary manslaughter charge after a grand jury indicted the actor in connection with the fatal shooting of a cinematographer on the set of the movie Rust in New Mexico in 2021. Prosecutors had dismissed charges against Baldwin last April, but a new analysis of the gun opened the way for prosecutors to reboot the case. Baldwin has always said he never actually fired the weapon, that he pulled back the gun's hammer, but not the trigger. Here's an interview with ABC's George Stephanopoulos.
It wasn't in the script for the trigger to be pulled.
Well, the trigger wasn't pulled. I didn't pull the trigger.
So you never pulled the trigger?
No. I would never point a gun at anyone and pull a trigger at them, never.
But a recent forensic analysis of the gun concluded that, quote, the trigger had to be pulled or depressed sufficiently to release the fully cocked or retracted hammer. Joining me is Joshua Kastenberg, a criminal law professor at the University of New Mexico Law School and a former prosecutor. The handling of this case by prosecutors has been very confusing. They dropped the case back in April. Why are they bringing it again?
Well, I think for a couple of reasons. And, I'm not privy at all to their internal discussion, but I think, number one, when the defenses were raised by the other defendant in the case, some of those defenses that were raised pointed in the direction of Mr. Baldwin. In other words, it's not fully my fault, it's also his, he didn't listen to me, that sort of thing. The other thing is that the prosecutors are stuck with this evidence. That's pretty compelling evidence, if you believe it. And what I mean is the FBI crime lab, when they investigated the firearm, concluded that the gun could not have gone off on its own, that the trigger had to be depressed by a human finger. And I think once that evidence is there and known to the public in New Mexico, the question then is, well, why isn't this going to trial? Particularly if Mr. Baldwin, who may be absolutely sincere in his memory, is saying, I didn't press the trigger, the gun went off on its own, and the FBI experts, who are the platinum standard of crime labs, are responding with, that's impossible. You're stuck with this, where is the truth? And I think that's what compels the prosecutors to go forward. Now, there were mistakes made, particularly in charging a crime that couldn't have been charged because of the date of the crime coming into existence. So you're absolutely right that the prosecution has been a bit confused, to say the least.
Why did the prosecutors this time bring this before a grand jury for an indictment rather than a preliminary hearing?
Well, there's going to be a lot of armchair quarterbacking, I suppose, on that question. I mean, the old comment is, you can convince a grand jury to indict a ham sandwich. On the other hand, a grand jury is specifically mentioned in our Bill of Rights. It doesn't apply to the states, but it's mentioned in our Bill of Rights. And I think what the prosecutor wanted, this is my guess, is ordinary New Mexican citizens, many of whom own firearms and many of them who understand the workings of how handguns operate, would come up with the right decision to make. Because if you take it to a preliminary hearing, all the judicial officer is going to do is say the facts meet the elements of the crime, and therefore you have probable cause to go forward, as opposed to a grand jury, which might say, look, Baldwin was in the wrong, but it doesn't rise to the level of a crime. This is a lawsuit.
Suppose Alec Baldwin did pull the trigger. He maintains that he pulled back the gun's hammer, but he did not pull the trigger, and the gun just went off. Why does that matter so much? Because when he was handed the gun, he was told that there were no live bullets in it, and there's not supposed to be live ammunition on the set. So why does it matter if he actually did pull the trigger?
Well, I think, that's a great question, and this is going to get into a nuanced argument that the prosecutor is going to make. And the nuanced argument the prosecutor is going to make is everybody who handles a gun has a basic duty of gun safety. And he had a duty to ensure the gun was unloaded or it was unsafe or inoperable before he put it in his hand. And the proof that he didn't do that is that he consciously pulled the trigger. I mean, that's going to be the prosecutor's argument. Whether it flies with the jury or not, I can't say. On the other hand, if what we have is a hair trigger gun that the moment someone put their palm, on the gun stock and the gun goes off, or it goes off simply because it's been cocked, Baldwin has a much better argument to say, I was exercising gun safety because I never put my finger on the trigger and pulled. So that is a critical piece of evidence that the prosecutor is going to do their utmost to try to bring out and prove guilt.
The new charges rest on two theories of involuntary manslaughter: that Baldwin either caused the death as an involuntary manslaughter by negligent use of a firearm, or as involuntary manslaughter without due caution or circumspection. So what's necessary to prove those charges?
So the first one goes to what we were just talking about. In order for the prosecution to prove beyond a reasonable doubt, they have to prove that Baldwin depressed the trigger without exercising appropriate gun safety. And that lack of exercise of appropriate gun safety rises to a criminal negligent, arena. So it's kind of recklessness. The second charge is that while Baldwin was engaged in a ordinarily lawful activity, he didn't exercise enough caution in a general sense, and that lack of exercise of enough caution resulted in the death of another. Now, put it a different way. Suppose you have a license to use fireworks on the 4th of July, and therefore your ignition of fireworks is lawful under state law. But you don't look around before you fire off rockets to see if there are children in the street or motorists driving, and a firework hits a kid and kills the kid. You didn't do anything illegal per se, but your lack of safety, your lack of overall caution for the general public makes that act rise to a crime. So those are the two theories. He can only be convicted of one if he's convicted of any. One of the things the jury might do is get confused between the two, and if they split between the two, then he's acquitted, because you have to have a unanimous jury that agrees with one theory and one theory only.
Yeah, I was wondering how the prosecution is going to handle that as they present the case at trial.
Well, so it's called charging in the alternative, and what the judge is going to tell the jury is you cannot find Mr. Baldwin guilty of both. You can find Mr. Baldwin guilty of one or the other or of none, but to find him guilty of one or the other, you have to have unanimity. So all 12 jurors have to agree that the prosecution has proved their case beyond a reasonable doubt.
Will he be tried in his role as an actor as well as his role as a co-producer?
Well, he's going to be tried as Alec Baldwin, and what that's going to entail is the prosecutor putting on evidence that he had a duty to even do, perhaps had a duty to do firearms training. And I know that there's been some talk that he missed that course. And, I think the prosecutor is going to try to avoid those titles to the extent they can, because I could see his very, very exceptional defense team trying to bring in evidence like this is the role of a producer and this is the role of an actor and this is why Mr. Baldwin did not have to attend that firearms training because he was acting in the role of an assistant producer, not an actor, or vice versa. I think the prosecutor is going to try to avoid all of that.
I ask that because as a producer, there have been allegations that the set was not safe. The safety on the set was neglected. Rust Movie Productions, the company behind the film, paid a $100,000 fine to state workplace safety regulators after a report into safety failures included testimony that managers took limited or no action after there were 2 earlier gun misfires on set. And the Santa Fe County Sheriff said that 500 rounds of ammunition were found, a mix of blank dummy rounds and suspected live rounds, which are not supposed to be on the set. So in his role as a producer, it seems like, that's right in his bailiwick.
Well, it would seem to be that way. You've got a very strong legal background, and there are rules of evidence, and I could see the defense team trying to suppress the fine, the investigation, to say that, look, Alec Baldwin has a role on the Rust movie set, but he is not responsible for the overall safety of the set in his role as an actor. That goes back to my comment that I think the prosecution will want to get that evidence in, but say it doesn't matter what his role was, but do its best to sort of water down titles and just say everybody's responsible. I think the defense is going to try to argue he's an actor, nothing more.
As far as I know, it still hasn't been determined where the live rounds came from. As I said before, there's not supposed to be live ammunition on a movie set. The armorer, Hannah Gutierrez-Reed, is set to go on trial next month. And according to Variety, the prosecutor offered her a favorable outcome last fall if she would help explain how live rounds made it onto the film set. She didn't provide that explanation for whatever reason. So does that matter that no one seems to know where those live rounds came from?
Well, it would be helpful to both sides, I suppose, to know where they came from, as long as Mr. Baldwin wasn't the source of them, which I doubt that he was, right?
He certainly hasn't been accused of that.
I can't speculate as to why Hannah Gutierrez did not accept, because, she has a right not to. That's a difficult question, and it actually might favor the defense, because if the defense is able to cast significant doubt on where those bullets came from, maybe the shipper, for example, maybe a manufacturer, maybe somewhere back in Hollywood, who knows? But it might make it palatable more to the defense to be able to argue, how was Baldwin supposed to know there were any live rounds? You can go back to that. I'm not saying it's a strong selling point to a jury, but it could possibly be.
It seems like the defense has a lot of arguments that can be raised. Whether they rise to the level of reasonable doubt is another question. And the biggest question is whether Alec Baldwin will take the stand in his own defense. I'll be discussing that with Professor Josh Kastenberg of the University of New Mexico Law School coming up next on the Bloomberg Law Show. I'm June Grasso, and you're listening to Bloomberg. Alec Baldwin is once again facing felony involuntary manslaughter charges after a grand jury indicted the actor in connection with the fatal 2021 shooting of a cinematographer on the set of the movie Rust in New Mexico. I've been talking to Professor Josh Kastenberg of the University of New Mexico Law School. Josh, there were apparently problems with the testing of the gun. The forensic expert had to replace parts of the gun which had been damaged by the FBI during its analysis. So I assume that there is going to be a lot of expert testimony about the gun, and the defense would bring that up.
Yes, I assume so. I think that's right. Anytime, the FBI or any other crime lab tests a material object, there's the possibility that the material object, in this case the gun, will be slightly altered. But I think the defense is certainly going to raise that as an issue. And again, it's hard for me to speculate on how far that would go with a jury. But look, I think for the prosecutor to succeed in this case, they have to go back to the keep it simple rule. And that is, Baldwin had a duty to observe and examine the gun before he put his hand on it. He failed to do that duty. It resulted in a death. And his statements that he made afterwards, that he didn't depress the trigger with his finger, conflict with, the expertise of the FBI. And if the prosecution keeps it that simple, that's, in my opinion, their best chance for obtaining a conviction. Unfortunately, all too many times, prosecutors want to defeat a defense before the defense is raised, and they put up lots of straw men and try to knock them down, and they leave the jury more confused and likely to acquit than they would have otherwise been at the start of the trial. So I think the questions of, does it matter that the FBI may have damaged the gun are great questions, but I think the prosecution is best suited by not raising those and objecting to them if the defense does raise them. And I mean, that's just my 2 cents in this, but I've seen enough trials and, examined enough trials after the fact where, for example, police officers are being charged with crimes, and it seems to me the prosecution overplays their case over and over again.
And the grand jury indictment only means that 8 of the 12 jurors found probable cause to believe that Baldwin had committed a crime. The standard at trial is much higher.
Yes. So probable cause is the lowest standard in the law, and they only need 2/3. At the criminal trial, it's proof beyond a reasonable doubt, and that basically means, in layperson's terms, if there's any reasonable doubt as to Baldwin's guilt, the jury has to acquit. And so that involves a bit of speculation. And in a criminal negligence case, which this really is at its root, there's a lot of room for speculation. That's why I told the New York Times that these type of cases are very difficult, and given the prosecution's missteps up till this point, there are added levels of difficulty in it. It's not an impossible case, but if you take the highest standard and you require a unanimous jury, it's difficult.
Can you explain how the prosecution's earlier missteps, of which there were many, would affect the trial?
Well, sure. Number one, it dragged the time out. So people's memories fade over time. Their certainty over what they did and what they saw fade over time. And that generally plays against the prosecution, because it's the prosecution who's got the duty to put on the case. Their witnesses are the key, obviously, and that's just the obvious statement. So that's one. The other is the general public in New Mexico, even if you find jurors who haven't established an opinion one way or the other on Baldwin's guilt, the general public in New Mexico knows about these missteps. I mean, the prosecutor charged him with a crime that came into existence only after the crime occurred. And, there's a basic constitutional prohibition about ex post facto charging. And the public in New Mexico knows this. So there may be a distrust built in the psychology of the jurors. And I think there may be a distrust in the psychology of prosecution witnesses at this point. And so I think some of what I'm saying is speculative, it's psychological, but on the other hand, anytime you drag a case out as the prosecutor, it doesn't work to your benefit.
The other thing at play here is that juries love celebrities. I mean, we've seen that time and time in cases.
They certainly do. I mean, the Beretta case resulted in an acquittal, and, I just talked about that case with my first-year criminal law students at the law school. And star power is everything. I go back to the Jimmy Hoffa trial in Washington, D.C. so many years ago, and, in the middle of Hoffa's trial in front of the jury, no less than Jesse Owens came up to him and shook his hand. Look, that kind of thing plays into the minds of the jurors. If Jesse Owens, if other athletes think Jimmy Hoffa is a good guy, then, in the psychology of the jury, Jimmy Hoffa couldn't have done the terrible things that, Robert Kennedy and the Justice Department accused him of doing. And it resulted in an acquittal. And that's an example of star power. So, yeah, people love a movie. They don't always love a movie star, but they love celebrities. So, yes, I mean, whether they're NBA players or Hollywood types, there are enough people who will love a star.
Of course, a defendant does not have to testify in his own defense, but in this case, does it seem like Baldwin would testify for many reasons?
I always tell my students, if you're a prosecutor, one of the first things you do when you're prepping a case is to pretend that the defendant is going to testify, knowing that in about 95% of all criminal trials, the defendant does not. But you have to prep that way. Having said that, in this case, I would say it's a 50-50 chance he testifies. And the reason is he's already made a statement that he didn't depress the trigger. And I think if he holds true to that and he testifies, it works to his favor. One reason why defendants don't testify is there are things that the judge has already suppressed that are damaging to the particular defendant. I don't think there's anything damaging to Baldwin that he would have to be afraid of on cross-examination. And if you look at that calculus, then why wouldn't he testify?
Exactly. And also he's very articulate. Another thing in his favor. Hannah Gutierrez-Reed, the film's armorer, is going on trial next month. Will Baldwin's attorneys learn a lot from that trial? Sort of a preview of the prosecution's case or how the prosecution works?
Absolutely. But they'll also learn not just how the prosecution works and a preview of the prosecution's case, but they'll also learn whether Hannah Gutierrez will end up being a witness for the prosecution against Baldwin, or whether what she has to say would absolve Baldwin if she testifies, and they may call her as a witness. So if she's acquitted in this trial, and there's a possibility that she would be acquitted, she could, depending on how the trial goes, she could end up being a witness for one side or the other. But I think they'll learn a lot, and I think that at least one of them will be sitting through the trial.
Are the charges against her the same as the charges against Baldwin?
Well, at their root, they are, but they're different theories to get to guilt. So she had a duty to secure the firearms, but her duty was different than Baldwin's as the armorer, as the primary gun handler.
The sentence, if he's convicted, is 18 months, but the assistant director, who pleaded no contest, got 6 months probation. So if he's convicted, would he likely get probation?
I would say so. That's out of the hands of the district attorney. That falls into the decision of the presiding judge at that point. I don't think that Mr. Baldwin has a criminal record. And as a first-time offender of a crime that doesn't really have any malice to it, because he didn't intend for it to happen, I would be surprised if he got any jail time. I mean, he may be sentenced to jail time, but then the judge abates the time on good behavior, something like that. But I would think probation is most likely in this case.
We were talking about the missteps of the first prosecution team. And my question is whether the current prosecution team is any better, because apparently Gutierrez-Reed's attorneys claim that the prosecutor inadvertently handed over hundreds of text messages between Gutierrez-Reed and her lawyer to a key witness last July.
If that's true, it's a major misstep, and it's carelessness of the highest degree. If it's true, and if it's true, what I would say is it's evidence that there's been a failure once again among the prosecution team. I'd like to think that the succeeding prosecution team is handling their duties with a closer eye and a greater degree of care, but I don't know.
It just seems like this case, it's one problem after the other.
Well, all I can say is that there seems to be a theme in this country right now that prosecutors are making cases more difficult than they need to be, based on their personal actions in the trial as opposed to the evidence. And you see that with the Trump case in Atlanta. It's this allegation of an unprofessional relationship between the elected district attorney and the lead prosecutor on that case. And here you see mishandling of evidence, the text messages and the like. If the allegation's true, it's making a case a lot harder than it should have been.
While I have you here, let me ask you, what do you think is going to happen in the Atlanta case?
It doesn't necessarily mean the trial is over and can't go forward. In fact, I don't think there's an issue with going forward. But what it means is that she has a huge cloud over her office that was self-induced. And I think he's a very, very gifted civil litigator. But this is not his experience. He should not have been the one who was picked. You could look across the state of Georgia, and there were probably far more talented and experienced criminal lawyers to pick. And so, it's a self-inflicted wound that should never have happened.
I know a lot of legal experts who agree with you on that, Josh. Thanks so much for giving us your insights. That's Professor Joshua Kastenberg of the University of New Mexico Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.